I have Ms. Nappinai here, who is a very senior lawyer and has been practicing for years in the area of cybercrime, in the area of banking and financial services, and she has a lot more of interesting areas to share with us. Ms. Nappinai, welcome to FinBusiness.
Thank you for having me here.
All the banks are very interested to know what kind of comparison is going to happen today, especially when it comes to data protection in between GDPR as well as the PDP, which is proposed by the government of India, or at least the papers which are there, which is in discussion.
The first level advantage that they have is that GDPR is already in effect. And GDPR has effectively and broadly been accepted as a golden standard for data protection across the world. Right? So you can start off by evaluating how GDPR impacts you and what are the compliances you would be called upon to do under GDPR. The next level becomes what is the distinction, if any, between GDPR and the PDP Bill. Broadly, the PDP Bill draws heavily from GDPR, but it also tries to evaluate or at least modulate it to the extent that is necessary for the Indian milieu. So in doing so, but one bad news in a way is that it is a lot more stringent than GDPR in certain aspects, and it gives a lot more leeway in terms of personal information as opposed to or distinguished from sensitive personal information in terms of waiver of consent. So when we look at a very broad comparison without going into the nitty-gritties, from a compliance perspective, banks would have to first at a first level do a verification based on the GDPR principles, data principles, then take into account what does the PDP bill say, and assuming it becomes law as it is today, what are the implications for them? And the largest stumbling block that is likely to be for banks will be the fact that the PDP bill provides for provisions where you can face criminal prosecution for violation of the provisions for processing of data. So there are specific data principles set out on how you would take consent and how that consent can be utilized, where do you have waivers for that consent, and what is the limitation even on those waivers. Where the difficulty happens is when we talk about personal information, all those exceptions to the mandatory requirement for consent are in themselves open-ended. Okay. So when you talk about open-ended provisions giving you certain rights, and you as a banker decide, okay, I have these rights, so let me utilize them, and you're processing data assuming you have these rights. And then suddenly you're faced with prosecution and then you have to show that you have not committed any offense, then that becomes very difficult. So you don't want to function with the Damocles sword hanging over your head.
Now, as a lawyer, how do you advise the bankers to go through the stepwise process of preparing themselves for the PDP?
The advantage that Indian banks have, we saw that in 2007-8 also, that we were one of the strongest in a situation where many were falling, like, a pack of dominoes. And that is what helps us. We are already strong in the banking sector, particularly with respect to compliance. It's built into their DNA. So one more level of compliance will not harm them, and I don't think it's a huge stumbling block for them. And secondly, once they understand that there is a very detailed, or assuming it is set out effectively as a process, then it becomes again part of the system. The only aspect where I feel that issues are going to arise are as follows. One, there are many compliances which are looked at just as tick marks. So the compliance under the data protection law should not be looked at as just a tick mark. It should be a higher level of compliance, which I like to set forth as conformance. Don't just comply, conform to the laws that are mandated. Two, make sure that you have continuous and periodic checks and balances. Don't treat a data audit merely as yet another compliance. Do it in an effective manner. Have multiple levels of checks and balances and keep verifying that each level actually works. Remember that everything when done in excess will cause fatigue. So you have to assume that if you overdo it also, that people will just get fatigued. Balance it out and ensure everywhere there is a trade-off. So if an organization, whether it's a bank or anything else, is going to have a trade-off, make sure it is not on material things, because that will then cost you a lot later. So you have to exercise sensibility, responsibility and caution.
Fantastic. That was a very interesting thought. And you mentioned a lot about, the kind of mysteries or the kind of ambiguity in the law. So if you can highlight couple of things that you have seen as per your experience, which can probably help the people to plan themselves.
So when you are, as an entity, are collating both personal information and sensitive personal information, and since we are talking about banks as a focus area, most of the data they are going to be collecting will fall within the sensitive personal information bracket. So when you are doing that, you have to keep in mind what exactly are the exceptions. Don't read into it something broader than what is actually given. So for instance, if you are concerned about or confused about whether a particular form of data will fall within sensitive personal data or personal information, because under personal information the heads for exceptions are a lot more wider than for sensitive personal information. If you have to decide, err on the side of caution and assume it is sensitive personal information, unless somebody tells you otherwise. From the regulator or the government's perspective, I would say, since you are thinking growth, since the whole focus of this law is to ensure, an industry which is based on service, etc., and India was losing a huge part of the big data and the data businesses pie. So you have now created a strong foundation to invite other nations to allow for data flows into India, right? It's not just about, it's not protectionism, which is the reason why the bill is being drafted, right?
Correct.
So when you're thinking of that, don't kill that business. Don't kill any business because of overreach, because all of us know where we need protection and where it can be relaxed.
Today, if there is a problem or a debacle in payments, or if there is a fraud, the kind of law mechanism which will help you to cover it is limited. So what are the kind of things that the lawmakers can do to make sure that this enforcement is to such an extent that the trust is reinforced in the minds of the people?
At the first level, what the government has done is they put the onus on the banks, saying that up to a limit, you are responsible irrespective of who is at fault. The second thing is there is some contributory negligence also to some extent. The third level is that they are also telling banks, take insurance and protect yourself back to back, so that you are not at loss. But these are not enough, because that shock that you get if you have been a victim of an offense, a fraud, a financial fraud. All of us have been victims of that, and we know, however aware we are. For instance, if our credit card has been misused, there is that moment of panic, right?
Correct.
You may be traveling, it has happened to me. I was traveling abroad and I had to block my card. Then what do you do then after that, right? So you need to have larger measures. I would say at a first level, create a better level of literacy, not only on, and that has been done a lot by banks, but that's not enough. What they've done is they have created literacy on what amounts, what is a phishing attack, etc., and all that, what are financial frauds, don't fall victim to that, etc. It's not enough to stop with that. You have to ensure literacy on, in the event you become a victim of financial fraud, what are your remedies in law? How effective are they? There are very, very speedy processes that are built into the Information Technology Act itself for you to go to the adjudicating officer, etc., and close it out. You don't have to rush to court and fight long drawn battles, etc. But then most of the customers do not know about these things, right? So you should not only create literacy about the kind of vulnerabilities, threats or pitfalls that are there, you must also tell them what are the remedies in the event of a violation, and that disclosure should be about both regulatory remedies as well as remedies through courts of law or tribunals, etc. The second level is, as a responsible organization, internally also they should create grievance mechanism which is transparent and effective, meaning it should be time bound. We understand that an internal mechanism will always first try to protect the organization, but the organization cannot be without the customer. So they have to put the customer in the middle.
Correct.
As the minute the focus becomes the individual or the customer, then everything else will sort itself out actually. And then both the customer as well as the organization will benefit, because once trust is formed, then the customer is likely to come more to the organization. They are not going to indulge in hoarding, or at least that's a utopian situation we would want, right?
Absolutely. I think that is fundamentally one of the most strongest statement that you have made, is put the customer in the front and try to create all that foundation of trust around him, so that can take the banks to the next level. Thank you very much for this wonderful conversation. We look forward to more such interesting conversations with you and take the banks to newer levels in the area of compliance and law.
Thank you for having me.
Thank you very much.